Good afternoon, everybody. My name is Nigel Nordone. I'm the head of tax here at Qdos, and in today's session we're going to talk about contracted out services and hopefully try and explain what they are in relation to consultancies and statements of work. If during the session you think of any questions, just pop them through on the Q&A panel and hopefully I will be able to get around to answering them at the end of the session. So in today's session, I'll be covering what are contracted out services, how are they relevant to the IR35 reform, the use of contractors in contracted out services, and identifying contracted out services. So firstly, what is a contracted out service? It's a completely packaged service provided by a third party, such as a specialist consultancy or professional services firm, and delivered to a client. It also sometimes referred to as a managed or outsourced service. There are many different types of managed service offerings, but the idea behind them all is to transfer the burden of the project delivery from a client to a service provider. A very basic example that I use, and I keep it basic purely because it's easier for me to explain that way, is if you own a business and you've got a set of offices and you want those offices cleaned, and you put the cleaning contract out to tender, and then my cleaning firm, Nordone Cleaners, wins the tender, and we agree to clean your offices for £50,000. Now I'm providing you the genuine contracted out service. So essentially what that would mean is that I, as the cleaning firm, will come in and clean the offices on a Friday evening, so they're ready for you on a Monday morning. And for that, we agree a contract over a set period of time for a set fee. As to how I deliver the services, I'm the service provider, so that's entirely up to me. Your business has no input into that. So if I choose to use one cleaner, I can deliver the services using just one cleaner. You have no input into how many cleaners I send or who those cleaners are. If I choose to use 5 cleaners, again, that's entirely up to me. If as part of this service I'm delivering, I realise that I've estimated my fees on using 5 cleaners, but the only way I can get offices clean to the standard that you require is by using 10, and therefore the profit level is either reduced to very low or nothing at all, that is my problem, my issue. The only interaction we should have would be for you to say, well, we're not happy with the services, and you would come back to me because you're not cleaning the offices as well as we would like. You wouldn't go to any of the individual cleaners. You wouldn't turn to me and say, well, we don't like those cleaners, so send us some new ones. Or it would be at the end of the contract to say, yes, we're very happy with the service and we'd like to renew. Or you would contact me if you wanted to either cancel the contract or possibly if you want to extend it to other services or other offices. So essentially, I would provide the services with virtually no interference whatsoever from you as my customer. And essentially, in a very basic form, that's how a contracted out service should work. So contracting out service is one of the 2 main ways in which a client business may engage third-party services in order to achieve their goals. The first is a provision of labour. So this is your typical contractor engagement. The end user or client will engage a supplier, so a recruitment agency, for example, to provide a worker. The contractor is engaged for their time and materials to the end user, or the end user could engage the personal service company directly in the same way. So if you look at the slide and the top provision of labour, normally you see the end user, the supplier, the worker. So you've got the end user, the agency, and the limited company contractor. And in that scenario, in a typical labour provision scenario, under the off-payroll rules, if everyone ticks the boxes of the end client being a medium to large business, it would be the end client that decides the status of the workers, and it would be the end client who actually would have to issue the status determination statement. In the second scenario, the fully contracted out services, this is where the end user or the client will engage the supplier to provide them with a complete service, similar to, as I've described with the cleaning company. For the completion of the project, the supplier can use whichever resources they need to do, but the supplier is responsible for the completion of those services. So under the off-payroll rules from April next year, if the supplier is a medium to large business, the end user would engage the supplier to supply the services, and it would be the supplier, the supplier of the services. If they're a medium to large business, it would be their responsibility to decide on the status of their workers and issue the status determination statement, and not the end user. So a fully contracted out service is different from the provision of labour. Some common features include that the service provider retains full responsibility for the management and completion of the service, as well as all resource and equipment needs. Service provision is for a defined period of time and for specific services. The client can pay a fixed fee for the complete service or upon certain milestones and deliverables being met. The service provider manages the whole service provision. Any issue with the services provider are addressed to the service provider, not to any of the service provider personnel. Again, in my basic example of the cleaning company, any issues with the standard of cleaning would come back to the owner of the cleaning company, not to any of the workers that they were sending to do the cleaning. And the service provider can send any individual to undertake the work, no requirement for personal service, and not typically for the supply of one individual. But obviously these lists that on this slide, they're not exhaustive, and there's other things that can be considered. But essentially, for it to be a genuine contracted out service, what you would be looking for would be that the client would have no input into who the personnel used were, how many personnel, how many personnel were used, and the client wouldn't be able to object to any of the personnel, because essentially the chances are they wouldn't even know who they were most of the time, and it would be up to the supplier to use whatever personnel they deem fit to deliver the services that were required. So HMRC, in their helpful way, will and do provide examples of contracted out services. So one of the examples they use is a Hospital Construction Limited fully contracted out service. Janice is a project manager who provides her services through her own company, Janice PPM Limited. The company has been contracted by Hospital Construction Limited to project manage the building of a new wing of a hospital managed by an NHS trust. The NHS trust has agreed to pay Hospital Construction Limited an amount of 500 million in payment for the construction project. Hospital Construction Limited is expected to pay their own staff and the contractor costs of the project. Janice's role will be to work closely with the NHS trust to understand and deliver the project requirements, and with the construction company and other partners to make that happen. The NHS Trust, whilst having an interest in the work of Janice, is not responsible for paying Janice's PSC. They will not be responsible to determine whether or not the off-payroll rules should be applied. So because it's a genuine contracted out service, then it is the supplier of the service that would engage with the PSCs, and therefore it would be their responsibility to decide on the PSC status and issue any status determination statements to the PSCs. An example HMRC give of non-contracted out services is under Teachers for You. Teachers for You Limited specialises in supplying teachers to local schools. One has asked the agency to provide a supply teacher for a full school term to cover an unexpected absence. The contract is worth 15,000 plus VAT. Hamid is a supply teacher who provides his services through a PSC, Hamid Tutoring Limited. He gets much of his work through Teachers for You Limited. He is paid for his work, found through the agency by an umbrella company, Team Limited, who deduct tax and NICs from his salary. So clearly that's not an outsourced service. Essentially, it's a provision of labour. They're looking for one person to provide a specific service, and it would be on, if you like, time and materials. So that is the labour provision. Therefore, if this contractor was a limited company contractor and not operating through an umbrella company, then the status decision would rest with his company, unless the client that they're engaged by was classed as a medium to large business under the off-payroll rules that are coming in next year. So what is a contracted out service? Generally, the contractual agreement for contracted out services will consist of both a master service agreement, MSA, and a statement of work. The Master Service Agreement governs the overall relationship of the parties and will include the high-level topics such as confidentiality and indemnification clauses, while the Statement of Work provides specific project details, usually in the form of schedule or addendum. So for each outsourced service provider, you would have an overarching master service agreement that sets out those high-level overarching terms. And then for each project with that supplier, you would have a separate statement of work, which details the specifics of that project. Together, the master service agreement and statement of work make up a managed service agreement for fully contracted out services. This builds the foundations for the engagement. It presents the expectations of each party entering into the agreement. It mainly serves to cut out any potential misunderstanding of exactly what is included within the costs of the project and what is not. Essentially, if you like, it works as a framework for both parties to understand what is required of them, when it's required by, and to what standard, what quality. So should at the end of the agreement there be any disputes, you would automatically refer back to the master service agreement and the statement of work to say, well, look, this is what we agreed at the start. We agreed to deliver X, Y, and Z. And for that, for us agreeing to deliver this within this time frame, for this standard, you agreed to pay us this amount of money. So the whole point of it is that it means that all parties involved know exactly what's expected from them and what the overall outcome they're trying to achieve will be. So the use of contractors in contracted out services. Whilst contracted out services are mostly traditionally between a client and service provider, many outsourced service providers frequently deploy similar principles for the way they engage their contractors, i.e. the service provider will engage contractors to complete specific elements of the overall contracted out service delivered back to the client. That's not to say a PSC needs to be involved at all or in isolation. A supplier may have a blend of different resources within a project, including their own employees. This method of engaging contractors is different to engaging a contractor for their time and materials. The contractor must be responsible for the specific outcomes of the project in the same way that overall contracted out service is a complete responsibility of the service provider. The term statement of work is often used to describe this method of engaging contractors, as well as with reference to the actual statement of work document itself as described previously. If you look at this, the use of contract and contract service slide, there you have the end user engaged, who has engaged the supplier to supply the services. So the contract is between the end user and the supplier, but what the supplier then does is they utilize services of individual PSCs to supply the services. But because it's a genuinely contracted out service, it falls on the supplier, providing that they're medium or a large business, to determine the status of the individual PSC contractors and issue the status determination statement to the PSCs. It doesn't fall on the end user, which is one of the main reasons clients and end users want to get involved in a genuine outsource service provision, because it alleviates them of the burden of having to make the status decisions, that issue the status decision statement, and also in a lot of cases, if they engage directly with the contractor, then they not only have to issue the status determination statement, they also have to become the fee payer as well. So, in respect of contracted out services, what is the impact on IR35 compliance? In Chapter 10, ITPA 2003, which you can find in the Employment Status Manual at 10010, HMRC states, a person who receives a fully contracted out service does not need to apply the off-payroll working legislation, as they will be above the client in the contractual chain and will have no obligations under Chapter 10, Part 2, ITPA 2003 in relation to that contract. The service provider providing the fully contracted out service must consider if it is a public authority or medium or large size entity to see if it is within the scope of the off-payroll working rules. So the off-payroll rules state that clients who are receiving fully contracted out services will be exempt from the legislation. So in the lead up to the public sector changes, and now in the private sector, the use of contracted out services was presented as a way for clients who would otherwise become responsible for the determinations of the contractor workforce to avoid the rules. As I touched on in the previous slide, if you're in receipt of a genuinely fully contracted out service as the end user, as the client, you don't have to worry about issuing a status determination statement or worrying about being a fee payer or anything like that. It falls back onto the service provider for them to issue the status determination statement, and for them, unless there's another agency in the chain, to become the fee payer as well. So the impact on IR35 compliance. Whilst in the provision of labour arrangement, the end client will become responsible for determining the IR35 status as a contractor engages from the 6th of April, whether directly or via an agency. If services are generally fully contracted out, the supplier of the services, i.e. the consultancy or the agency, is considered the client for the purposes of IR35 and therefore carries the responsibility for determining the status of the contingent workers. End users are therefore keen to utilise fully contracted out services in order to avoid any obligations and the off-payroll rules. Passing these on to a supplier, the requirement for determining IR35 does not disappear. However, it's simply responsibility of another party in the chain. As I said, provision of labour, it becomes the client's responsibility to issue the status termination statement. And then if they contract directly with the PSC, they also are the fee payer. If they contract via an agency, the agency becomes the fee payer. Fully contracted out services alleviates the client of that burden. So you can understand why clients are keen to adopt contracted out services, but you can also understand why, in our view, this will become a very high profile compliance project for HMRC going forward, because I'm sure it won't surprise you to hear that there are businesses out there who believe they're operating through a fully contracted out service, but they won't be. So can you avoid IR35 with contracted out services? Putting in place a managed service and statement of work will not avoid IR35 obligations if the services are not genuinely fully contracted out. Whilst a legitimate practice when it is a genuine arrangement, there are many who believe that putting in place a managed service agreement for contracted out services or statement of work will be sufficient in demonstrating that fully contracted out services are being provided, and so we'll present this as an option to clients as a way of removing the client's IR35 obligations while selling contractors an outside IR35 status. However, it's important to remember that engaging in this way does not automatically achieve this. If it's not a genuine reflection of the true arrangement, it could create far more risk for all parties involved. As is with the case with IR35 in general, it's imperative that the structure of any written contract is borne out in the reality of the true facts of the engagement. And it's the day-to-day working practices, the actual reality of the day-to-day working practice will always take precedence when HMRC carry out any form of investigation, whether that's in a labour provision or whether that's in a contracted out services. Ultimately, what is in place has to be robust. It has to stand up to scrutiny. And if it doesn't, it can lead to problems with our friends at Her Majesty's Revenue and Customs. So the use of contracts and contracted out services. HMRC are able to see through any arrangement between a supplier and an end user that is masking a fully contracted out service, but is in fact a resource provision. In turn, this would see the end user responsible for determining the IR35 as opposed to the supplier. This could be seen as a failure of the end user to meet their obligations, which could then see the end user liable for any alleged tax loss and possible penalties if they're seen to have not taken reasonable care in correctly establishing the nature of the relationship with the supplier. Under the off-payroll rules that will be coming in the private sector from April 2021, the end user is responsible for issuing a status determination statement and also is responsible for paying any for any additional liability that HMRC would come about if a status determination statement is incorrect, or until they discharge their duty to issue a status determination statement. So in other words, if you as an end client have engaged someone for a contracted out service and HMRC carried out an investigation and said, well, actually, that isn't a genuine contracted out service, essentially it's a disguised labour provision, HMRC would say you haven't complied with the legislation as the client, because as it's a labour provision, it is your responsibility to issue the status determination statement. And until you do that, your liability hasn't been discharged. So in other words, if HMRC came in and deemed it not to be a contracted out services, that it was a labour provision and those contractors should have been inside of IR35, any additional liability will fall on you as the end user because you haven't issued a status determination statement. So there's a big risk there that if You enter into what you believe is a contracted out service with the supplier, and it proves not to actually be a genuine contracted out service, that there's a liability that HMRC would want settled, and they would want you as the end client, as the customer, if you like, to settle that liability. The other thing you would need to consider on that point before we move on is that if they did deem the responsibility is yours and they hadn't taken reasonable care, they may levy penalties. So can you avoid IR35 with a contracted out service? Is it appropriate to change a provisional labour agreement to a fully contracted out service? And you should be replacing the written agreements, but the nature of the provision remains the same. This is particularly relevant when organisations are looking to change existing arrangements from provisional labour to fully contracted out services. It may be that the supplier in question is not set up to manage projects themselves, and simply replacing the existing written agreements with an MSA and statement of work is not enough. It's imperative, therefore, that professional advice is taken as to whether the managed service structure is appropriate. Making a change, especially to an existing contingent labour model to an outsourced model, can be cumbersome, challenging and risky. Establish what and why you want this change. Is there a genuine business requirement? If IR35 is the driver, you don't need to take extreme steps. You can compliantly and efficiently manage to meet your obligations with standard resolve provisions. Essentially, contractors can be outside of IR35 if their working practices are are genuinely self-employed. So irrespective of whether you're using contractors as part of a genuine outsourced provision, or contractors are being used on a labour provision, they can still be outside of IR35. It just hinges on what are their working practices. The only difference, obviously, as a client, is that if it's a labour provision, then you have to take responsibility for issuing the status determination statement, whereas if it's a genuine outsourced provision, that responsibility passes to the supplier in the chain. So how do you determine if a service is fully contracted out or if it's more akin to provisional labour? There are a number of factors which we would consider. These would include, but aren't limited to, if the supplier is a specialist in delivering outsourced services, whether services are entirely led and managed by the third-party supplier, whether the supplier is responsible for managing the resources required, how the work is actually provided, i.e. the extent to which any workers interact with the client staff, how the payment of the project is structured, who the workers report to or liaise with, whether the client can request the services of a specific individual, and what their IR35 processes are. Are they determining status where they should be? So these are factors you need to consider. There are other factors, but obviously this is just a snapshot of the sort of things that you should be looking at when thinking about engaging an outsourced provision. So actions to take now. We're less than 6 months away from the 6th of April 2021, when, as far as we know, as of today's date, the off-payroll rules in the private sector are being introduced. End users will need to take care that that the contracted services are genuine, and that's what, they are, just that. End users should identify suppliers who are or may be using limited company contractors to deliver their services to you. Review the nature of the services being provided. Review the actual working practices as well as the contractual terms governing that service provision. A contract is massively important. A good contract, managed service agreement is massively important, but it's the working reality. As all things with IR35, it's the working reality that is where HMRC would really concentrate their efforts in reviewing any outsourced provision or any labour provision that's in place. What are the actual working arrangements that these contractors are operating under? Confirm an agreed approach to IR35 responsibilities and confirm in writing. It's important to be able to demonstrate robust due diligence. HMRC like paperwork. It's something that if you say something to HMRC, if you're ever unfortunate enough to have an HMRC investigation and you say something to them, they will want evidence of it. they will want you to prove what you're saying has happened is true. So anything you have that supports that this is a genuine outsourced service provision, you want to document it, so that should you ever be unfortunate enough to have a visit from our friends at HMRC, you can say, Mr. Officer, Mr. Inspector, Mrs. Officer, Mrs. Inspector, this is what we do and here's the evidence to prove it. Implement a communication engagement plan with suppliers and contractors where necessary to conduct IR35 determination and the off-payroll rules. IR35 can be managed effectively whether a resource provision or fully contracted out service. And with any of these, whether it's labour provision, whether it's contracted out services, communication is key. All parties within the contractual chain need all, to coin a phrase, to be singing from the same hymn sheet. We at Qdos do provide a review service should you need an expert opinion on determining whether your arrangements are fully contracted out or not. Just to get in touch with a member of the team and we'll be more than happy to help. Thank you for listening. As I said at the start, if you have any questions, please feel free to ask via the Q&A panel. I can't promise I'll answer them all because I've noticed there's quite a number have come in already. We hope that you found this series of technical webinars informative. Recordings will be sent out tomorrow. And of course, if you need any assistance with your I-35 preparations or further advice, please feel free to get in touch. I will try and answer some of the questions that have been asked. And the first one is, as an end user, we don't directly employ trades and labour, only white collar freelance. How safe are we to take a blanket approach to labour in saying they are outside of I-35? In addition, as the end user, do we need to send a status determination letter to all trades or labour that will go to the agency who supplies them, as most will be paid in CIS direct agency, not limited? IR35 applies to limited companies. So if they're on pay-as-you-earn, it doesn't apply. CIS it can, depending on how the contractor is operating. If they're operating through a limited company, IR35 would need to be considered. But again, under the new off-payroll rules from April 2021 in the private sector, you only have to consider the rules if you would be classed by HMRC as a medium to large business. And the definition for that is in the Corporation Taxes Act, but essentially what it is HMRC say, if you can answer yes to 2 of the 3 criteria, you are a medium or large business. And those criteria were 10.2 million or more turnover, 5.1 or more million on your balance sheet, or 50 or more employees. So if you can answer yes to 2 of those 3 criteria, you're classed as a medium or large business, and therefore the off-payroll rules will need to be considered when you engage limited company contractors. In the situation where a company engages a contractor via an agency, but then places that contractor in the systems into a systems integrator to do project work for the SI, who are responsible for doing the status determination statement? I'm going to be honest with you, I don't know what you mean by systems integrator, but if you engage the contractor via an agency, again, as far as I'm aware, if you're then saying you get a contract from an agency and then pass that contractor, if you like, on to a third party, to a client, then whoever engages the service of the contract, so it would ultimately be in that scenario, if it's a labour provision, it would be the client that you've passed the contractor on to, who would be the engager, who would have to issue the status determination statement. They would issue that to your business. You would then have to pass that statement down to the agency, who would then pass it down to the individual PSC. Are time and material consultant services deemed as consulting or contracting? Again, it would depend on the terms of the contract, and it would depend on what the working practices are. If you talk about a limited company contractor, ultimately, if it's without knowing the ins and outs of the contract, it could be either. It could be a service provision or it could be a labour provision. Is it possible for an agency to operate a statement of work model without the need for an outsource agreement? Or is a statement of work inextricably linked to an outsource agreement? No, I mean, a statement of work is used in the provision of labour. It's simply, you have the contractor who has the contract, the limited company has the contract, either with an agency or with the end client, if they're contracted direct. And a statement of work is used basically to set out what the client wants the contractor to deliver, what's agreed. So again, should the contractor get to the end of the contract and the client say, well, we're not paying you because you haven't delivered such and such, the contractor can say, well, look, here's my statement of work, and you told me this is what you wanted me to deliver, and that's what I've delivered. So you can use a statement of work. It doesn't have to be part of an outsourced provision. Part of the problem across the board is that HMRC never give anything more than simplistic examples rather than examples that address real life contractual relationships and associated issues. How many people want to know about a supply teacher? No, I understand, but if you go to the employment status manual, and if you go to, if you bear with me a second, I'll just tell you roughly. If you go to ESM 100.10, in there, that talks about contracted out services and the other examples that it uses to show what is and what isn't a contracted out service. I'm not saying that will necessarily give you all the information you need, but it's a starting point. Is the fact that oil and gas operators are ultimately responsible for the safety of the offshore installation, so to some extent will always dictate how the work will be done. But the work will be done under the supervision of the offshore installation manager, and where and when the service can provide it, indicative of an operator tending to be end user of PSCs provided by a supplier. I mean, essentially, if there's a limited company contractor, PSC, who is provided to an end client who is in the oil and gas industry via an agency, then yes, the end client, the oil and gas business, would become the end user of the client and then have to issue a status determination statement. Whether that contract will then be deemed to be inside or outside of IR35 would then come down to the key status tests and the working practices. Do you need a new status determination for each service that you engage a contractor for? If you engage, no, I mean, essentially what would happen is if you engage a contractor under a contract and a statement of work, just using the statement of work to define the parameters, once that contract ends and the contractor started a new contract, you would then want to do another status determination statement. Or if the terms and parameters of the contract were to change, you would issue a new status determination statement. Where a PSC is engaged on a contracted out basis, non-time and materials, by a supplier, does that supplier still need to do an SDS? Yeah, even if it's a genuine outsourced provision that the supplier is providing to a third party, and the supplier, we're working on the theory that the supplier is a medium to large business and the off-payroll rules apply, then it's the supplier to issue the status determination statement, not the client. That's why people or businesses like to use outsourced services models, because it takes the responsibility away from the client, if you like, and passes it down the chain to the supplier. If the supplier, i.e. consultancy, is in a small, medium enterprise business, not medium large, who then is responsible for the status determination? If it's a genuine outsourced provision and the supplier is a small business, then the status determination, if you like, stays with the contractor, limited company contractor, because the contractor is engaged by the supplier, and if it's a genuine outsource service, then it's for the supplier to determine the status if they're medium or large. If they're not medium or large, then it falls back to the contractor, as it does currently. So the receiver doesn't need to run the status, the service provider's SME, in this case, does the PSC have to? Yes, yeah, basically that's, yeah, so I've just seen that correct. But yeah, ultimately, even if the client is classed as a medium or large business, but it's a genuine outsourced provision by a supplier who's a small business under HMRC's definition, then it's the PSC that determines their own status. So I'm just reading, make sure I'm not answering the same question again. So if the supplier is providing a fully contracted service as a consultant, but still classed as small, engages PSCs to provide someone, so yeah, is the consultancy exempt? Yeah, essentially, as I said, if the supplier is classed as a small business and it's a genuine outsourced provision they are providing, then the responsibility to determine status falls back to the individual PSC. Will we get a copy of the slides after this session? I do believe they are being sent out, yes. Do you have to have a status determination if client or consultancy is liable? I'm assuming if you're saying that they're deemed inside of IR35, then yeah, I mean, you would have to issue a status determination statement to the contract to say you are inside IR35. What if client puts it into their terms with you that they pass the IR35 liability to you? Is that legal? No. Ensure that the only way that the client, and we're talking about a labour provision now, not outsourced provision, a labour provision, the only way the client discharges their liability is to issue the status termination statement and to take reasonable care when they do that. If they do that, then the liability passes down to the fee payer. What happens in the case of the supply chain where the contractor goes via an agency into a private sector company who then supplies that contractor to a public sector end client? Is a private sector company regarded as the end client and so makes a determination, or should we pass to the public sector end client? If it's an outsourced service provision, so the private sector company is providing an outsourced service to the public sector, then it stays with the private sector company. If HMRC were to overturn a status determination statement made by the end user in a provision of labour situation, which entity is liable for any payments due? So if an end client, if the chain is end client, agency, personal service company, if the end client makes a status determination statement and takes reasonable care, even if HMRC investigate and say, oh, Mr. End client, we know you've deemed these contractors outside of IR35, but you're wrong. These contractors should have been deemed inside of IR35. If they've taken reasonable care, the liability stays with the fee payer, the agency. It only would transfer back to the end client if the end client hadn't taken reasonable care. This will be the final question that we've got time for today. And it's, are there any factors which would put a business at the top of the list for HMRC, for a HMRC visit, or will it be random? I presume that HMRC will not be looking to visit all companies, as this would be impossible. No, when the off-payroll rules have been introduced, and this view is essentially my view more than anybody else's, but I believe, partly from my experience from when I used to work for HMRC, and I realised how time and financially strapped they were, basically. The off-payroll rules have been introduced to reduce the burden on HMRC to carry out investigations into one-person limited companies, because to carry out an investigation into a limited company is incredibly time-consuming and incredibly costly. As an example, I've represented clients in IR35 inquiries that have lasted 5, 6, 7 years. I hasten to add those ones I won, so in case anyone was wondering. But the point being, it's very labour-intensive, very time-consuming. So with the off-payroll rules, rather than go and look at one individual contractor, they can go into a business and look at the business that might engage 50 contractors or 100 contractors. It would be far quicker. Under the current rules, HMRC would sort what investigations they were going to carry out for IR35, because they would look at tax returns that are submitted where it was high dividends, low salary, salary below taxable limits. That would, instigate an inquiry in a lot of cases. That was the criteria they use. It's going to be different for businesses. So what they will look at, I expect, in my opinion, again, it's just my opinion, they will look at the bigger businesses first of all, because obviously the bigger businesses are going to engage more contractors. And I believe they will definitely be looking at outsourced service provisions, because as we've seen in the past, contractor loans, things like that, there's lots of businesses that will put forward a solution that guarantees X, Y, and Z, and it's been checked by a tax barrister, and it's all above board when it really isn't. And I think that's what will happen with outsourced service provision. So there is no set criteria, and sadly for us, HMRC will never tell you why they carry out an investigation. When I was an inspector, I was told you could never tell people why you're investigating, and they've never changed that stance. And I left the revenue 14 years ago. So you'll never know why, but obviously the businesses that engage the most contractors will, to me, my view, would be more likely in HMRC's line of fire, if you like. Thank you very much for taking the time to listen to me. Thank you for all the questions. I'm sorry I didn't get around to them all. As I said, I think the recording of this webinar and probably the slides will be sent out afterwards. And if you have any questions or any concerns or any issues, or you'd like us to help you with anything, then please feel free to get in touch. So thank you very much. And I will let you go back to doing something far more important than listening to me. Thank you very much.